Kevin, I wanted to start with you. I'll just read a little bit from this article. WikiLeaks founder Julian Assange allowed to seek appeal against extradition to the U.S. So this came down earlier today in the United Kingdom. WikiLeaks founder Julian Assange has won permission to try and appeal against the decision to allow him to be extradited to the United States, where he faces charges under the Espionage Act. The decision to extradite Assange has rested on his mental health. In January 2021, a magistrate's court ruling found that Assange could not be extradited as it would be oppressive by reason of his mental health. The High Court overturned that decision in December, saying Assange could be extradited based on the United States assurances. On Monday, Lord Chief Justice Ian Burnett and Lord Justice Timothy Holroyd denied Assange permission to directly appeal December's ruling, leaving it to the UK Supreme Court to decide whether or not to take up Assange's appeal. So, Kevin.
Well, so that's legally confusing in a way for Americans that CNN isn't bothering to unravel or like untangle so that it can make sense. So if I can just take a moment, it's actually fairly standard for the High Court of Justice, which is an appeals court, to not grant permission. But when they do that, they're basically ending their role. And now it frees up the defendant, or it frees up the person who is the appealee or the appellant, can now go to the higher court and bring their case. So until they do that, they have to be dealt with. And so now the High Court is done, and now it's all within the realm of the Supreme Court. And the part of this that actually matters, because there's been a lot of focus on did they or did they not grant permission. And I wouldn't get hung up on that, but CNN did, because they don't really understand this case beyond the fact that they have a pipe dream of hoping that Julian Assange can be brought to the U.S. and interrogated by the FBI so they can reopen the Mueller investigation into Donald Trump. But the real thing that people need to pay attention to is that the High Court certified a point of law. So when Julian Assange's legal team appealed this High Court decision that overturned the district court decision, and when the U.S. government won and they sent it back to the district court in December, then Julian Assange's team appealed, and they had to bring up points of law that the High Court would recognize were of public importance. Excuse me. And then when they did that, if the High Court agreed that either of these points were of public importance, then it would make it possible for them to appeal to the Supreme Court, which is what they want, so that they can overturn the U.S. government's victory. And they were able to achieve this. I have the pronouncement in front of me from this morning, and the point of law that was certified is that they acknowledged, the High Court did, even though they ruled against Julian Assange, they acknowledged that the question of what circumstances can an appellate court receive diplomatic assurances from a requesting state which were not before the court of first instance in extradition proceedings is a question that has not been settled by the Supreme Court before. And so it can go there. Julian Assange can go to the Supreme Court and file an appeal and say, we don't think it was proper, because again, I'll wrap this up and then you can ask me whatever. The main problem here is the district court, Judge Vanessa Baretzer, in January of 2021, ruled it would be oppressive for mental health reasons, as you read in that CNN article, to extradite him to the United States. And Julian Assange won. The U.S. appealed. And so, the issue now is, I'm now tangled. See, it's all convoluted. I'm getting lost in it.
Basically, to dumb it down for the audience, it sounds to me that Julian is, first of all, there was a local magistrate. Yes. She ruled that he cannot be extradited. Then a higher court above that local magistrate overturned it, provided U.S. assurances. The same U.S., by the way, that it came out was plotting to kidnap and assassinate Julian Assange. That country's assurances was why the higher court overturned it. Now it seems Julian Assange's lawyers are making the legal argument to the Supreme Court that the Supreme Court of the United Kingdom has never before issued statutes or weighed in on the diplomatic assurances from another country. Do I have it right?
Well, wait. No, so thank you for saying that, because it actually reset my mind, which is a kind of a little bit fried. So the issue. So what the High Court is doing is they're giving the Assange team an opening by saying, "All right, we've settled the question, but we actually can see that the Supreme Court has never ruled on this issue. So the door is open for you to go ask the Supreme Court if they will hear your appeal," which is good. I don't know if you have the clip available or not, but Stella Morris made a pretty good statement outside of the court, and maybe you want to play it.
We do. We could play that now.
The High Court certified that we had raised point of law of general public importance, and that the Supreme Court has good grounds to hear this appeal. The situation now is that the Supreme Court has to decide whether it will hear the appeal. But make no mistake, we won today in court.
From what she's describing, is she's pointing out that point of law, which seems to be the specific legal term for why the Supreme Court they have to decide to hear it, but why the Supreme Court now could come into play.
But without that certification, the door would be closed and they would not be able to appeal to the Supreme Court. So the High Court is signaling to the Supreme Court that there are legal issues that the Supreme Court could hear. And so it's very bizarre because on one hand, they did not grant permission for the appeal. But on the other hand, yes, they did, because by giving certification to a point of law, that means that Julian Assange's legal team can go forward and appeal.
And the other thing also is, I haven't read anything on timeline here. I mean, I've seen cases in the United States in appeal and back and forth between 3 different levels for 20 years. So Julian Assange had a mini stroke, I believe, in October. Yes. I spoke with his brother at a protest in New York City. Brother said they fear he's going to die. Came out that your brother had a mini stroke, I believe. How is his health right now? Because I know it's been deteriorating.
Yeah, I mean, it's just another, you know, he's feeling the pressure and it's immense, and it's years and years. It's been 11 years since he was first arrested in the UK. This is going to be his 3rd Christmas in a maximum security prison, and the pressure is bearing down on him. And you know, we can't be surprised that he's going to have a stroke. I mean, what's next? Is he going to, you know, we live in fear that he won't survive this.
How long could this potential, just to get word from the Supreme Court if they will hear the appeal? We don't know how long that's going to take, and then if they grant it, how long that's going to take.
Mm-hmm. And if I can just get one more piece of news out there that has flown under the radar. So they asked for certification on 3 points of law. And you may be wondering, if anybody who's watching this closely, what happened to the other 2 points? And what were they, and why did the High Court reject them? And so they asked for the Supreme Court to be able to further review their concerns that they have about how Julian Assange could be subject to torture or inhumane treatment in U.S. prisons. And the Supreme Court essentially said, well, that's already been settled. We don't need the Supreme Court to look that over. And so Amnesty International actually put out a statement, which I'd like to take a moment just to bring in here quickly, because I think, again, it refocuses things on the issues that matter, that are of more importance than just simply, you know, is he sick or not? Is he mentally stable or whatever? So this is from Massimo Moratti, who is Amnesty International's Deputy Research Director in Europe. And he said, while we welcome the High Court's decision, or they said, while we welcome the High Court's decision to certify one narrow issue related to the U.S.'s assurances as being of general public importance, and to allow the Supreme Court to consider granting the appeal, we're concerned the High Court has dodged its responsibility to ensure matters of public importance are fully examined by the judiciary. The courts must ensure that people are not at risk of torture or other ill treatment. This was at the heart of two other issues the High Court has now effectively vetoed. Torture and other ill treatment, including prolonged solitary confinement, are key features of life for many people in U.S. federal prisons, including those imprisoned on charges similar to Assange's. The ban on torture and other ill treatment is absolute. It cannot be upheld by simple promises from a state that it won't abuse people. The Supreme Court should have had the opportunity to deliberate and rule on all of the points of law raised by Assange at this crucially important point, but the High Court limited its scope to do so. If the question of torture and other ill treatment is not of general public importance, what is?
There's another critical question, which I think I know the answer. Well, why is Biden and Merrick Garland able to do this so freely? Because you have a press corps in this country that
it doesn't hold
frankly has very selective principles when it comes to freedom of journalism. Tina, if you remember, I don't know, it was an NPR reporter who questioned President Biden's press secretary. Why don't we just send free tests home to everybody? It was so simple, but finally a reporter asked it.
Finally.
But Biden's press secretary. Biden's press secretary had egg on her face. Before you know it, then the media picked up on that. And before you know it, in a week, we're going to set up a plan to send 500 million tests. That's the power of the media. If the media would choose, I'm talking Brian Stelter. I'm talking the New York Times, who distributed a lot of these Chelsea Manning leaks with WikiLeaks. They partnered on it. If the media would, all right, whatever, you think Julian Assange worked with Russia, that's not true. But even if you think that, there's a broader principle here, Kevin.
That's more important, yeah.
Brian Stelter was at New York Times, by the way, when these leaks were being published in 2010.
But I'm telling you, you can call me naive. If tomorrow you had a band of the White House press corps on Jen Psaki, on Biden about this, then it would get picked up. Biden would drop this in a New York Minute because they respond to pressure. But you don't have that pressure from the media because, frankly, I think the media does not want to lose their access to the CIA, the FBI, and et cetera, et cetera.
I mean, Title 42 is being defended still. I was just going to say another example right this week, Title 42, a Trump administration separation of children at the border. They're defending that this week, too. So they're continuing to turn their back on campaign promises. They campaigned on, we're not going to do the same things the Trump administration did, but the Justice Department is doing the exact same thing. And you're right, the press corps in Washington, D.C. is not holding him accountable, not asking questions, basic questions.